Hello everyone and welcome to our fifth video tutorial on the topic of judicial precedent. So far we've been looking at how judicial precedent works, and we've looked at the hierarchy of the courts, ratio decidendi and law reports. We've also looked at the different methods that the courts can use to try and avoid a precedent that they don't wish to follow, distinguishing, reversing and overruling. And we've also looked at the specific methods that the Supreme Court and the Court of Appeal can use to avoid their own past decisions, i.e. the practice directions 3 and 4 and the exceptions in Young and Bristol Aeroplane. In today's tutorial, I'd like to look at evaluating the doctrine of judicial precedent by looking at the advantages and disadvantages of the system. I've given you quite a lot of detailed notes in your booklet about this, and there's lots of articles that you could read around this area that would supplement your notes and assist you with this further. It could be on the exam on section A, you get 5-mark questions asking you to evaluate judicial precedent. So that's what we're working on today. So let's start by looking at the advantages. So I've put the key advantages in orange down the side here, and I just wanted to talk you through these to check that you understand what each of them means. So first of all, first major advantage of precedent is that it should lead to a just system. Now what I mean by just is fair. An advantage of precedent is that it should lead to a fair system because a case is going to be treated exactly the same as a similar case that preceded it. And that's what fairness demands. And I'm sure for you as a student, you'd feel very unhappy if you were treated differently from another student when you did exactly the same thing. And of course, the same applies in court, that we would hope that similar cases are treated the same way. And this links to the second advantage here, that if you are treating cases the same to previous cases, that should lead to impartiality in the system. Because judges, if they are simply applying a binding ratio from a previous case, it means that they are less likely, hopefully, to be making decisions based on prejudices. Because they're not going to be looking at that particular defendant and what that particular defendant has done. They're simply going to be applying the rule from how, for instance, duress is no defence to murder. They're not going to be bogged down in this specific defendant. And hopefully that will lead to impartiality, which is what justice demands. And it leads us to that very famous expression, justice is blind. And hopefully justice will be blind if we're simply applying the ratios from a previous case. Another major advantage of precedent, which we've mentioned before, is certainty. That if you are following a binding precedent from a previous case, it means that lawyers are able to advise their clients accurately because we can predict what an outcome will be based on the case that's been decided previously. So when we were looking at ratio decidendi, we talked about the case of R and Howe. And we looked at that case in criminal law, and the ratio decidendi in the case of Howe was that duress, trying to highlight it here, duress is no defence to murder. So that was our ratio. Now, when the House of Lords decided that duress was no defence to murder, that created certainty in the law because the House of Lords was the highest court. We know that it binds all the courts below. And therefore, we know that in any case involving murder, the defendant is not going to be able to plead duress because we're going to have to follow this binding ratio. So it leads to certainty in the law, which is really important in advising clients. Now, another advantage you could argue is that there's flexibility. Now, you've got to be slightly careful with this because most of the time, the higher courts we know are going to follow their own decisions. So they bind the courts below and generally they bind themselves. And we will see in a later slide that a disadvantage of precedent is that it can actually make the law quite rigid. But there's always two sides to the story. Here we're arguing that precedent actually allows for a bit of flexibility. Now, in the case of R&R, the House of Lords made the decision that a man could be guilty of raping his wife. Prior to that case, marital rape was not a crime. But obviously that was very outdated, and the House of Lords said, no, society has changed, the law also needs to change. So the fact that judges are able to overrule decisions, as we saw with BRB and Harrington overruling Gaddy and Dunbrack, for instance, there is a degree of flexibility there with overruling, with using the practice directions, because we are able to change the law to take account of changes in society. The fact that judges are essentially reasoning by analogy when they're using judicial precedent, it means that they're able to find practical solutions for situations that Parliament didn't foresee when they were creating a particular Act of Parliament. So, for example, in the case of DICA, if you recall when we were studying criminal law, the ratio in DICA was that inflicting HIV can amount to GBH. Now, the Offences Against the Person Act 1861, the draftsman at that time, I'm sure, would not have possibly foreseen that in the future people would be potentially inflicting biological disease as a type of assault on a person. So that wasn't foreseen at the time that the Act was written, but judges, by reasoning by analogy, are able to respond quickly, they are able to make decisions in cases and deal with real life problems such as those seen in DICA and also more recently in the case of Roe as well. And when judges are making these practical solutions, like I just mentioned in DICA, that also links to this point here, that precedent allows for legal growth. And we mentioned earlier that there's something called original precedent. Now, an original precedent is where a judge makes a decision in a case that has never had to be made before. And we've got some cases of that. Bland was a famous example we've looked at. Donoghue and Stevenson is a case that we'll study next year. That's an example of a brand new original precedent. In that case, judges had to make a decision on whether manufacturers owed a duty to the ultimate consumers of their products, and they decided that they did. And that was the case where Lord Atkin developed the neighbour principle for duty of care. So a massively important case that shaped and basically created the law of negligence as we now know it. And another major advantage of precedent, of course, is that it helps judges to learn. So inexperienced judges or new judges that are being appointed to the lower courts in the hierarchy, they are applying the decisions from judges in higher courts. And in that way, they are learning from their more experienced brethren. And judges are never in a position where they say, I don't know, I've no idea what to do here, because they can always look at previous decisions. And as I said before, they can reason by analogy and come up with a solution. So precedent is helping judges to learn and to apply the law effectively. Okay, so if we go on to consider some of the key disadvantages then, again, I've listed some of the key points here for you in orange, and we'll just talk through and check that we understand these. So first of all, judicial precedent is extremely complex. And there's a great example we could use here. I've given you some details in your booklet. Dodd's case. Dodd's case was a Court of Appeal case where 5 Court of Appeal justices all said that they couldn't find the ratio decidendi from the House of Lords in a previous decision that they were trying to follow. So I've mentioned to you before that when you read a judgment, the judge won't say this is the ratio of a case. He simply makes his judgment, and lawyers have to read it back and work out what the most important principle is. But that can be very complex, and it's not always easy to work out what the key point is. So it can be a very complex process. And the volume of law, you've got to consider that here. Every year, more and more cases are going to court, more and more decisions are being made, and we are adding to the volume of our legal system. And so the sheer volume of cases means that applying judicial precedent becomes very complex. And judges have to be aware of all of the cases and the most recent cases that have come to court in that area. And that can make advising your clients quite difficult as well. Now, on the previous slide, we mentioned that a key advantage of precedent is that it leads to certainty in the law, and generally it does. But we've also got uncertainty as a disadvantage, because whilst the law is certain when the judges are applying the ratio from a past decision, we actually don't know when they're going to try and avoid a precedent. And we are sometimes taken by surprise when judges choose to overrule a case or choose to reverse a case, or even if they choose to distinguish it. We don't know if the judge is going to try and do that, and that can lead to uncertainty. So there was a famous case here, Murphy and Brentwood. This case overruled an earlier case called Ans and Merton. Now, Ans and Merton wasn't a very good piece of law, and it had been disapproved of for 12 years by judges. But when it was suddenly, well, not suddenly, it took 12 years to be overruled, but when the judges did take the decision to overrule it, that was quite surprising because it had existed for 12 years, and people were surprised, and that led to uncertainty here about the law, specifically relating to property sales, because that's what these cases were about. Rigidity is another disadvantage. Now, we said previously that on the whole, not on the whole, sorry, but we said previously that flexibility is an advantage of precedent, and it is, because the law can develop. But a disadvantage is that precedent can make the law very rigid. If you think about the doctrines based on stare decisis, to stand by what has been decided, if someone sticks to stare decisis and never moves from it, the law becomes very rigid. And we've just mentioned Ans and Merton, and I said that it took 12 years for it to be overruled. So the law can stagnate and become quite old-fashioned. If you think about the case of R and Brown, which we looked at in criminal law, that's a poor decision in my opinion, in the opinion of many academics, but it's still technically good law. And that was the case on sadomasochism and consent. And until that's overruled, the law's rigid, stagnating, it's not keeping up with modern times. These 3 points here we can sort of link together. If you think that judges are making decisions and effectively making law when they're overruling, when they're making decisions like they did in R&R or Donoghue and Stevenson, where they're making original precedent, that's unconstitutional. Because our judges are only supposed to apply the law, they're not supposed to make it. And if you think back to separation of powers, the judiciary should be in the judiciary, in the arms of state. They shouldn't be in the legislature, the lawmaking body. It's undemocratic, of course, because they're not elected, unlike the House of Commons in our Parliament, and that judges generally are drawn from a very narrow social spectrum. So do we want this narrow social spectrum making such big decisions on things that affect us, such as in the case of R&R, for instance? And another disadvantage of precedent, although hopefully I'm sure we all agree that the decision in R&R was a good one, marital rape should definitely be illegal. But when you think about that, it actually has retrospective effect. Because when the defendant in this case raped his wife, what he did was legal. But when he came to court, the judge at that point decided, actually, times have changed, it's now illegal, so you're guilty. So we're punishing him for something he did retrospectively. Okay, let's leave it there.